on comparative constitutional law, but actually to engage in a conversation about how judges use comparative constitutional law. So I am hugely in debt of Justice MacMenanim. All of you, of course, must have seen his resume, and you might know about the important judgments that he has delivered, both in terms of the rights of children and in terms of the legal aid work that has happened. But I would like to introduce him in terms of the interactions that I've had because of the course that we are starting. He was absolutely gracious in the first instance by saying that yes, he would be happy to come all the way, and that he would want to teach students and as many students as possible. We didn't have a cap on the numbers, so we didn't try to leave out students, because he said that he would like to meet as many students as possible. And throughout the month that we have spent putting this course together, he has shown great magnanimity in materials, in time, in terms of effort. He said that he would write out lectures and he would circulate them for all of you. I don't think I would have done so much for a course, and I'm sure all of you have the constant complaint that I hardly give out notes for my class, and I expect students to figure out for themselves what I'm saying to them, and I wouldn't want to figure it out for them. So I think he has put in so much into this course that that I'm sure all of you will realize as you go through the course that there's been a lot of work that has happened from his end, and for that I am very, very grateful to him. And what has also been outstanding in the way in which we have interacted is something that students of this law school particularly will find very familiar. He started off by saying that he doesn't want to look at the entire subject in terms of merely what courts have said, but in terms of looking at comparative constitutional law as an exercise where two countries which have a common heritage and which have shared a certain political understanding of the state and of the nation, and of countries which have both resisted colonialism, maybe in different ways, but that common history is where he would like to start with. And I said that was so important for me, that as constitutional law teachers here, we keep trying to emphasize the fact that you don't start constitutional law with a clean slate. You don't look at constitutional text as the beginning, as is how you start looking at constitutional law, but it's very important to look at the history and the politics behind the drafting of a constitution. And I was delighted that that's where he wants to start. And today's lecture is going to focus on this shared heritage that we have. And for all of this, I'm immensely grateful to him, and I'm very happy that he has found the time to be with all of us. So, as an introduction to the course, what I'm trying to do is maybe raise a set of questions more in terms of, I'm sure these are questions in your mind as well, of what are we trying to do here? Are we merely looking at two constitutions, because all of you also have the text of the constitutions with you? Are we simply trying to say, okay, this is the Constitution of Ireland, this is the Constitution of India, and there are certain commonalities, and so what? And it is important that that is not what we're trying to do at all. We're not trying to look at the text of the Constitution simply in terms of saying, okay, there are these commonalities and similarities. But what we're trying to do here is to say that when constitutions and the terminology that is common within comparative constitutional law scholarship has either been in terms of a borrowing or in terms of a dialogue. But what we're also trying to engage with is what is the significance of a shared political background in the interpretation of a constitution. What is the idea with which people, when they wrote out a constitution, had a particular vision? And I'm sure this ties in very much with standard constitutional interpretation in terms of whether you want to call it textualism or originalism or any of the other words that we're familiar with when we're looking at constitutional interpretation. But what I want you to do is to say, okay, if you're looking at constitutions as negotiated documents, and that's again an idea that Justice MacMenanim was delighted with when we shared the constitutional morality article with him, and he said that is so important to look at a constitution not simply as legal text, but to look at constitutions as a negotiation. I wouldn't want to use the word compromise, but as a negotiation between different people from different ideologies with very different aspirations of what they want from the constitution, but and the only thing that is possibly shared is the fact of the working of the constitution and the manner in which we want the constitution to work. So when we say that, okay, there are these two countries that we're comparing, and we all know that we have borrowed a certain idea from them, does it mean that merely because that particular constitution has moved away from that idea, or that particular constitution has engaged with an idea in a particular way, will that necessarily mean that we also engage in the same way, or we also have the same reaction towards what we have as the directives? But that again is not what we're trying to do here. We're not saying that, okay, this will happen in Ireland and so this should happen in India. That's something I really want to put right out there as saying what we're not trying to do. So then what is it that we are trying to do? What we are trying to do is, in the words, and if you have the time to read Professor Bakshi's introduction to the comparative constitutionalism in South Asia, please look at it. What we are trying to do is to say, okay, these are post-colonial constitutions. What are the continuities and what are the discontinuities that we are observing in both the constitutions? And how have courts, as the interpreters of the Constitution, as one of the interpreters of the Constitution, dealt with the question of continuity and discontinuity? Now, all of us, at least in India, know from your history classes as well that the constitutional text that we see today is largely based on the Government of India Act. So, to a certain extent, we're all familiar with the continuity, even if we had resisted that colonial power. We couldn't afford to completely reject everything that we had in terms of governance. Now, you could explain this in many ways, and I'm sure Ambedkar had his own logic for why he wanted to continue with these structures of governance which were oppressive. He might have had his own reasons, and we can get into that at some point of time. But the fact is that we did not discard these structures. And that is part of the problem, and that is also part of the solution. That we couldn't afford to move away from these governance structures. But the fact that we couldn't afford to move away from them, does it mean that we are in perpetuity bound to these notions which are not ours? So today you heard about the rule of law, and the rule of law as a principle has been a principle that's actually been used against those countries which were colonized. Where at the same time, and though we don't explicitly have rule of law in the Constitution, we didn't have a trouble reading it into the Constitution, even if we were familiar with the highly formalistic understanding of rule of law. But we still say that, okay, while we accept certain notions of the rule of law, we will find a way of integrating them in our constitution, in our interpretation, in a manner that is going to be substantially different from the way in which it originated. So this is what I think is the crux of what we're trying to do. Look at what is it that we haven't been able to get away with, what is it that we have deliberately continued. Whether you want to say it's deliberate or not is again a question of ideology. Do you think that we made a choice in continuing with certain structures? Or we didn't make a choice in continuing those structures and we simply adopted them for convenience sake? The explanations could be different. You could say it was a convenience question, it is not an ideological choice at all. Or you could say, no, we have deliberately committed to a particular way of governance. Either way, those are explanations, they are not the facts. The fact remains that there is a continuity. The fact is also that there is a discontinuity when we say, no, this is not the way in which the Indian Constitution needs to be interpreted. So when I see these two different approaches that the Supreme Court has taken towards comparative constitutional law, for example, where you have decisions which have almost entirely relied on comparative law, and then you have a set of decisions which are saying, no, comparative law is not going to be useful for us in this particular exercise. What you have clearly demonstrated before you is that there is a continuity when you rely on the Government of India Act. and you say that, okay, this happened in a pre-constitutional time and we're simply continuing with that in a post-constitutional time as if there has been no break, as if there wasn't a freedom struggle and as if there wasn't an independence struggle and as if there wasn't a constitution that was drafted. So you do see an interpretation where the continuity is very obvious, and you do see an interpretation, and you have judges who have remarked that in a new constitution, in an independent India, this is not an idea that we want to be continuing with. We are merely trying to point out that these are ideas which are very important for lawyers today. And that's one of the reasons why I'm so delighted that a member of the judiciary is willing to engage in this conversation of what is it that judges are thinking when they are either using or not using comparative constitutional law. And this is a first person account, right? This will not be our analysis, or as John would say, over an analysis of judgments of what people are doing. You possibly have no clue what is happening in their minds, but we have a first-hand account of what is happening in their minds when they are using and not using comparative constitutional law. So what we are trying to do is, there is this scholarship on comparative constitutionalism and comparative constitutional law. That scholarship has spoken about both the merits and the demerits of comparative constitutional law. So if you want to look at what is it that comparative constitutional law has to offer, then very clearly what it has to offer is in terms of an improved judicial reasoning. Sure, when you have a well-reasoned out judgment from a particular jurisdiction, you have to have good reasons not to be able to accept that line of thinking. And if you actually don't want to accept that line of thinking, then you will have to engage with that question in the same manner that that particular person has. So it automatically improves the entire process of judicial reasoning. That is very clearly a reason why there is an increased demand for comparative constitutional law. There are other reasons in terms of saying, okay, there are shared values that people of a particular jurisdiction have deliberately opted for. So when we have opted for values such as equality and liberty, then there is no reason why we'll not look at jurisdictions which have expounded these values. And so that is an important reason why we do comparative constitutional law. And there is an understanding that when the judiciary performs a similar function, and the reason of judicial review expanding across the world, which is something that we will also touch upon, that there is a reason when institutions perform certain functions, then they will look at experiences and what is it that courts in other jurisdictions have done when they are engaging with that question. These are all reasons which are offered as why we should do comparative constitutional law. But for me, the most important reason of doing comparative constitutional law is tying back to the first point that we were making, that you don't see constitutions as texts. You don't see constitutions in terms of the way in which it was written, but you look at constitutions as negotiations. So the minute you say, okay, a constitutional text is a negotiated text, and the negotiation happened because of this, there is no reason why we should not depart from that text if we are able to look at the reasons for why the text came in the first place. So the fact that we are not then looking at the constitution at a particular point of time in history as if that is the beginning of an idea, but we are able to look at the way in which that document merely reflects an idea already in existence. And the minute you're able to say that, then comparative law becomes natural, right? Because you're saying that the Constitution is speaking to a certain set of values which were prevalent and which were found, and hence the Constitution is speaking to that. And the Constitution is not the source for this kind of an understanding. And I think in India, this is something that we have very well accepted with the basic structure theory, when we are saying that no, there is an understanding of the Constitution which doesn't necessarily come from the text of the Constitution. But the downside of comparative constitutional law is also not easy to counter. The downside of it, starting with saying, okay, does everybody know what they're doing when they're doing comparative constitutional law? Do the judges understand I mean, I'm not trying to say this in a derogatory manner at all, but when you are taking a particular interpretation, do judges really have the time to see how that interpretation was actually came into place, or what are the various contexts? Because that becomes an academic exercise. I mean, that is an exercise of people who have been closely reading the Constitution over a period of time on a particular area. But when you merely pick up a doctrine doctrine from another jurisdiction and try to use it in your own, you might or might not be completely aware of the connotations of that particular doctrine or the nuances of that particular doctrine, and then when you try and apply it in other contexts, and we have seen examples of this, there is a break even with the constitutional text and the constitutional identity. And that's the second downside of doing comparative constitutional law. And when we're touching upon this idea that constitutions speak to a certain value, there is a constitutional identity, then every constitution has its identity, right? Then how are you then going to borrow from an idea that is part of another identity into your own identity without necessarily saying that then you're losing your identity when you're borrowing that idea? And it is not an easy question to answer, that when you're borrowing so freely and you're talking about identity, how does that then resonate with the question of borrowing, and how responsible borrowing needs to be when you're looking at this question? And these are not easy questions, but these are questions that I think all of you should keep at the back of your mind when you're doing this course. This is a course where we understand the downside and the upside, and when we are proposing a particular idea, we want you to be able to interrogate it in terms of these pros and cons, and then be able to take maybe a call on whether you would say that the pros outweigh the cons. But I think this is something I want you consciously to keep at the back of your mind when you're listening to anything that we are going to say. Now, given that there are these upsides and downsides to comparative constitutional law, and we are saying that there are questions of identity, there are questions of origins, there are questions of politics behind constitution, how do we then proceed? What do we move on to when we are doing this? And the reason, in spite of these pros and cons, for the reason for doing this is that it is absolutely necessary. There is no way we can escape from the idea that when a constitution has been made in a particular manner, borrowing ideas from across the world and borrowing ideas from its own colonizer, borrowing structures from its own colonizer, at what point do we say that it is still worthwhile to continue with that structure, and at what point are we going to say, no, this is something that we are not going to continue anymore? And this is a necessity that every interpreter of the Constitution, whether it's a judge, it's a student, it's a lawyer, it's a teacher, everybody who as a citizen when we interpret the Constitution, this is at the back of our mind. Okay, we have this text, but which way do we go? How much do we acknowledge its history? And at what points of time we say, the history is not going to bind us in our interpretation of the Constitution. And this is where I see that doing comparative constitutional law allows you this political understanding of the Constitution, which is absolutely necessary. It talks about the method in which we are doing this investigation, and that I think I will spend a minute on the kinds of scholarship that is available on comparative constitutional law. So you have a method of doing comparative constitutional law, which is not necessarily looking at judicial process exclusively. You're looking at constitutions, and you're actually able to say that there is a quantitative method of doing comparative constitutional law. And this is something that, again, people who are coming from a social science background and people who are saying, okay, we need facts and figures and we need impact. If we're saying comparative constitutional law is important, then where has it seen its impact? In what do we see? And how do we prove that it has or doesn't have an impact? If you're looking for evidence for comparative constitutional law, and can comparative constitutional law also be an evidence-based exercise, or are we looking at comparative constitutional law largely not in terms of an evidence-based exercise at all, but looking at comparative constitutional law as a reasoning-based exercise? And this, again, I'm only flagging it out as a question that all of you would need to think about when we are moving ahead with this course. Now, to briefly introduce how we're going to go about in the next 6 days, we have an introductory lecture today, which is largely looking at a common heritage between Ireland and India. And again, when we say a common shared heritage, we're merely pointing out the similarities, and I'm sure all of you will also note the dissimilarities between the constitutions. And we are moving from here into the question of constitutional interpretation. We will be looking at this whole idea of a textual and the idea of originalism in constitutional interpretation. And then move into the question of how has this idea of a constitutional identity been used both in terms of comparative constitutional law, but we are seeing that this idea of an identity of the Constitution is not necessarily something that's coming from comparative constitutional law, but we are finding that this can be used in areas other than merely looking at even the Constitution. You're looking at legislations now, where you're talking about whether the identity of the Constitution has been violated by an act of Parliament. And that, I think, is a very important development, particularly in comparative law, where you will see and we will show you how different jurisdictions have used this idea of an identity in a manner very different from the way in which we have understood identity. And this is something that I think will resonate with all of you when you start looking at how the question of identity has been used by the Supreme Court of India. So from these three, in a way, stage setting modules that we're doing, we're going to be picking up three instances, and these are more in terms of case studies, where we would expect you to get back to us to say, okay, when we have spoken about this theory, how do you see this entire logic playing itself out? And so we've chosen an instance of rights, wherein in terms of picking a particular understanding of a right, we have used comparative law, and has that been a useful exercise, or has it not been a useful exercise, and how does it flow out? And we have picked a question on structure, on governance structure, where we are going to be saying, okay, how does this idea of separation of powers play out when we use comparative material, and what is it that comparative material can give you when you're looking at these two? And with these two, where we hope to see a lot of interaction with all of you, and we hope that you will be able to come and give us instances, other instances that you can flag out from what we have already discussed. We are looking forward to seeing your interactions at that time, and then we hope to have a concluding session where we're going to try and see if we can, if we say that we have reached somewhere in our understanding of comparative constitutional law. So with this introduction to the course of what we are trying to do, I now request Justice MacMenanim to start his course with an introduction to all of you.
I want to thank Professor Vasanthi for her stimulating, thought-provoking and terrifying introduction. I am reminded of the French figure in the 16th century, I think, who was told on one occasion that he was speaking prose, and he was very pleased because he'd never realized that he was speaking prose before. In the same way, I feel now that I'm working in the realms of constitutional theory at a level which we judges don't always engage in. Professor Vasanthi has set out the general framework. I want to thank her. I want to thank NALSAR for the extraordinarily generous invitation to come and speak with you. And I have to say frankly, I think NALSAR stands comparison with any legal learning institution that I've seen in the world. I want to thank Malavika Prasad, who some of you know, and my own assistant Naomi Lyon-Sweeney, who have made the emails run hot between Ireland and Hyderabad for the last month. And what I want to do is just explain to you how I feel about this process. I feel as if when I began to read the story of India's independence, as if we were being given the opportunity of standing on the shoulders of giants, men and women who are involved in a huge nation-making process, state-making process, which was unprecedented. And people talk about the United States Constitution making in the 1780s. But, and I'm not being flattering in saying this, it's nothing compared to the achievement of what was done in 1946 to 1948. Nothing compared to the complexity, the diversity, the extraordinary difficulties which were faced by those men and women. And people talk about Alexander Hamilton and James Madison, but I feel confident in saying that people will be looking at this century, the 21st century, the Asian century, and looking back on the way that these men and women shaped Indian society, and will be looking to that as a paradigm. We don't always, when we're looking at things from within, we don't always have a good realization of perspective. It takes a long time, for example, for countries to write a proper history of themselves. It took us 40 or 50 years. And you've had the opportunity, I've recommended Guha's book, which is, to me, is a wonderful case history of history with perspective. Why is the subject important? Because it gives us perspective. And I think it's important for a number of reasons. The first of these is that constitutions are not an artifact. They're not what the French called an objet trouvé, something you meet in the middle of the road. They're something which have context, which cannot be seen as just a mere arid text, or as one prominent American justice said, a text written by dead people, or a dead text. I don't see it that way at all. And it seems to me that's an arid and redundant way of looking at constitutions. I think there's no greater fallacy than that. Because I think what we have to do is look at the thinking that lies behind constitutions, which underlies them, and the values which are expressed in them. To my mind, constitutions are dynamic. They speak from the past. They live in the present, but they speak to the future. The process, therefore, understands that we look at the origin of constitutionality and engage in constitutional comparison in a way which I think isn't always done when we're thinking about law. So I'm going to use biological metaphors first. The origin of the concept, where these ideas of the rights of man come from. Rights of men and women, as we should say now. Who conceived them? Then we should look at issues such as evolution and morphing. I'm again using a biological term. How do the values evolve and sometimes morph in time, even in the drafting process of a Bill of Rights or a constitution of a nation state? And I emphasize the words nation state. I'll be coming back to that later. And I think we also have to understand that a constitution gives expression to a framework of interlinking and mutually supporting institutional structures. So we're dealing with the rights of individuals and structures, constitutional structures. And then we have to understand that our analysis and the way in which we collectively look at constitutions is an incremental process. You do it by degrees, level by level, almost like archaeology or geology, where you look at various layers. And by understanding precedents and origins and comparators, we understand the constitutions we're dealing with more deeply. And I think this is particularly important because we're living at a time, as we learned earlier today, when the rule of law is under challenge, is under stress, is under threat. And what we have to do, all of us lawyers, is to ensure that such supports, such bulwarks as there are to protect the rule of law, both nationally and internationally, are there and can be relied on. So this is then the value of comparators. We're living in, or we were living in the 1960s and 1970s, and I'm old enough to remember that, in an era of internationalism. I wonder whether that's true any longer, or whether nation states are becoming more inward-looking, and whether nation states are going to almost revert to a Hobbesian universe where life is nasty, brutish and short. So I think it's time, why I personally have appreciated doing all the research I hope I've done, is because it's so important to understand the mutually supportive roles that courts and the academy play in the development and application of these values. So, what are we dealing with here? Well, we're dealing with two constitutions. This little constitution, which was drafted in 1937, and we can have a look at it later, anyone who wants to. And we're dealing with that constitution's big sister, who was drafted between 1948 and 1946 and 1950. And why they are sisters is obviously because we can detect the constitutional DNA running through the two of them. And that happened as a result of two or three things. First, the affinities which Congress, the National Congress, felt from the 1880s onwards towards the Irish freedom struggle. And secondly, that was concretized in the 1940s by the work of Sir Benegal Rao, who engaged in a tour of including Canada and Ireland to engage in a process which Dr. Ambedkar called ransacking all the constitutions of the world. So I'm thrilled to be here. If I had thought we'll be dealing at some stage with how it happened that I ended up being a judge, that was certainly not a preordained thing. And how it happened actually is a result of comparative constitutionalism. Because just to tell a story, in 1974, a very unhappy, existentially threatened young man was studying law in King's Inns, just like all of you now. And I read a book called Gideon's Trumpet. That existentially threatened person was me. And this book was Gideon's Trumpet, written by Anthony Lewis. And it was about an American law case called Gideon versus Wainwright. Anyone heard of Gideon versus Wainwright? It's the one that established the right to legal aid. And I was sitting there and thinking about it. I was working in a legal advice center for students. And the following week, in came a woman whose son was going to be tried. There was a legal aid strike going on in Ireland at the moment, not the first, not the last. And it occurred to me that this might be an opportunity in order to see whether a case could be brought to the courts to establish a constitutional right to legal aid. And it did. And I brought it to a friend of mine. I was a student then, Frank Clark, and he said he brought it to senior counsel, and they brought the case to the High Court, where we won, and to the Supreme Court, where we won, and it's now probably one of the more cited judgments in Ireland. but it all hinged on an American precedent. And the lesson is not to say anything great about me, but there's another lesson too. If I hadn't read the book, would the thought have ever occurred to me? So one of the things we'll be looking at, as well as everything else, is the theory of this, but also the practice, the way in which precedents from foreign jurisdictions are cited in the courts. So I'm going to talk a little bit about myself, because when you're a lawyer, when you're practicing lawyers, incidentally, look around you. Has it ever occurred to you that if you look around you, it's very likely that there will be one or two people sitting in the Supreme Court in 30 years' time? Because oddly enough, what happened was the barrister I asked to act in the case, Healy versus Dennehu, is now a person who sits beside me in the Supreme Court every week, and he was recently made our Chief Justice. So look around you, identify the person, the people who are going to be on the Supreme Court of India. You're there somewhere. And why it's important is, I think that when I know the Supreme Court of India entertains the citation of authorities from other countries quite frequently, and I think it's important that we look at the discipline and the theory of that process. So if we look at just talking about, I'm only going to talk about myself, not out of egotism, but because I think you're going to see some echoes of India. If we go on to deal with any other pictures, I'll say, well, that's what happened to Ireland. That's a historical analogy as well. Okay, well, but just to keep you awake, I just want to do something, and just to show you where our relationship begins and ends. Will you all shout out for me, please, in Hindi? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Now I want you to do it loudly, and I'm going to see which side does it better. Okay, this side first. 1. Come on, you can do it. Very good, but I think the other side would do better. Now, away you go. Go on. In Hindi, please. And now I'll do it in Irish. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Interesting, isn't it? And that shows you our Indo-European background and the way in which our background, our tradition, our history actually goes back thousands of years. And we can just leave the PowerPoints for a moment. I became a High Court judge in 2004. I had a fairly broad experience there. Then after that, I got involved in doing child law. I got involved in doing commercial law, broad experience. And I learned as a High Court judge that you ask questions like who, what, when, why, where. And all of you here are dealing with questions of legal principle. That's what legal education is about. But when you're actually dealing with legal practice, you start with facts. Then you move on to principles, and then you go on to the application of those principles to the particular facts. That's what you do when you're in the High Court, or in a High Court. When you're in an appeal court, you check whether the trial judge engaged in error. In other words, did he or she err in the way in which she applied legal principle? But Supreme Courts are different, and I hope we might be able to have a quote from Justice Dixon, but maybe not. I'll read it out to you anyway. There was a Canadian judge called Justice Dixon who said, the task of expounding a constitution, I'm going to read this really slowly because it's important. The task of expounding a constitution, listen to the word, is crucially different from that of construing a statute. A statute defines present rights and obligations. It's easily enacted and easily repealed. A constitution, by contrast, is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power, and when joined by a bill or a charter of rights for the unremitting protection of individual rights and liberties. I'll get that distributed to you later on so you have it, because it's a really good definition of what we do when we're engaging in constitutional interpretation. He went on to say that once enacted, a constitution's provisions can't be easily repealed or amended, and it must therefore be capable of growth and development over time to meet new social, political and historical realities, often unimagined by the framers. So I think that says it all in one sense. Constitutional interpretation is different from statutory interpretation. And what I want to do is engage in a voyage of discovery with you, where you're going to teach me as much as I hope I might be able to impart a little bit of experience to the process of how rights definition and rights identification was engaged in various jurisdictions across the globe. And we'll be looking at constitutional interpretation, just as we were talking about what Justice Dixon said there, because we've got to realize that when we're interpreting constitutions, it is a different process. And you don't go searching through the books, I use that term with a little bit of innuendo, you don't go searching through the textbooks looking for some apposite quote. It has to be contextualized. The statute or the constitutional provision must be comparable. The context must be comparable. Because the worst that can happen is that courts engage in an eclectic collection of quotations from other jurisdictions, as if that validated the judgment. It doesn't. And most of all, I want this course to be fun, and I don't want it to be taught in any sense that this is going to be a high-pressure pass-fail, oh my God, my future depends on this course. It doesn't. I want to assure you of that. This is going to be fun, but it is going to be, I hope, interesting fun. So, I was very struck when Professor Vasanti was talking about what judges think. It just occurred to me how important punctuation is, because if you just change it, it would be, what? Judges think? Which of course means something slightly different. But they do think, and we do think. And even though we might be sitting there up on the bench looking rather like statues, there's a lot going on all the time. So, at first instance, we engage in one process. On appeal, we engage in another type of process. And when we're engaging in constitutional interpretation, we're really looking at a living tree. And why the question of comparative constitutionalism is important is very largely connected to the huge growth in judicial review since the Second World War, because courts have become immeasurably more powerful than they were at any time previously. I don't have to say that to you in India. I've learnt about the historical background. I would never have understood it without an understanding of the historical background of what happened in the 1970s and then what happened in the 1980s. And we look at that as well. We look at the question of whether or not, as Professor Vasanti touched on, whether this is a hard science or a discipline. And I, because I'm an anarchistic judge, will be asking questions like, how easy it is it to categorize and to impose labels on particular approaches which are adopted by courts. And not only that, but theorists who seek to place a label on particular approaches to constitutional comparison. It's something we come back on again. But to anticipate a little bit, my thesis, my argument will be that there are elements of contingency and chance. There is the important role of the advocate, and that goes back, for those of you who are students of Indian constitutional history, we'd be looking at the pure coincidence of the fact that in 1965 a German constitutional scholar came to India, delivered a lecture about basic structure. And it was because of that, and the essay that was written on foot of that by the German constitutional scholar, that the question of basic structure was placed before the Indian Supreme Court. Say he hadn't come, or say nobody had spoken to the advocate who was involved in the case before the Supreme Court and told him about the lecture. And then there are judges' own researches, and then against this, I'm not arguing always at all on the basis of contingency and chance. Against this, there are the really marginal cases where courts look very hard at precedents from abroad, because they're the marginal cases where we sometimes attach greater weight than others. The very fact of a judgment on a particular issue carries weight with it. The Americans have done this, the English have done this. We'd better have a look at it a bit more seriously. So, what I want to do is also emphasize that this is a process where there are and must be rules and principles that govern judicial conduct in the interpretation process. It is not one, I believe, where one can go and just select something from a book on the shelves in the wonderful library you have over there and say, here's something. It's the very thing, and I'll engage in a little bit of ad hocery and I'll just put it in like salt or pepper or a little bit more curry. You don't do that. You have to be so careful to ensure that the context, statutory and constitutional, is the same. But now I want to say something which is a difficulty, because I think that having looked at the theory, this is of course where quite genuinely there is no one right answer. There was a Prime Minister of Ireland who was rather academic, and he said the rather remarkable thing once. He really did say it, actually. He denied he said it. But he actually said during the conference once, that's all very well in practice. How does it work in theory? So what we have to do is look at the way in which this works, both in practice and in theory. But I don't believe there's one right answer. But what I deprecate is the process of ideological hardness in judiciaries, which you sometimes see around the world now, where, to my mind, an over-rigorous theoretical approach may stand in the way of attaining justice. Hard law, it's true to say that hard cases can make bad law, but hard cases can make law as well. So we're looking at principle and theory, and then we're looking at practice and pragmatism. And we're looking at the art, and I use the term advisedly, of judicial determination. And that's not to say that the process is devoid of principles or rules, but what we want to do is look at not only what judges do, but why they do it, based on what judges did elsewhere. So, on the other hand, this is not a course in Indian constitutional law from Bharati to Olga Tellis. I'm not going to purport to engage in a process which I would be absolutely unfit to engage in. What I am trying to say is that there are risks of an over-theoretical approach, but what we have to try and do is focus on what are the approaches which are permissible. And this is where we're going to have an exchange, because what we are engaged in together is an intellectual voyage of discovery in an area which is quite new. And I'm tempted, in fact I will use a metaphor which I used in conversation the other day, which is to say, and I say this respectfully to myself and my colleagues, that in Europe there's a bird called a jackdaw, and the jackdaw is very attracted to bright things which it sees on the ground and brings it back to the nest. And we judges are a little bit like that. If we see a citation or a quotation that says exactly what we want to say, well then we take it like the jackdaw does and bring it back to the nest of our judgment. And we're a little bit prone to doing that, but what we have to do is ensure that what we're doing is we're not bringing, to make some metaphor, we're not bringing a jurisprudential cuckoo into our nest. So then we look at whether cosmopolitanism can go too far. We'll go from the United States to the United Kingdom to South America to South Africa, and we look at schools of interpretation, our approaches to interpretation. And we're going to have to do that, because in order to understand what the judges were doing in any particular jurisdiction, you must not only look at what the great citation or the quotation is, but also what their approach to judicial interpretation was. What were they engaging in? A literal interpretation, originalism, as you'll have heard of originalism in the United States, textualism, you'll all have heard of that in the United States, but we all, Ireland, India, England, all derived our basic form of interpretation from textualism. That's a close examination of the meaning of the words. But I've already quoted Justice Dixon as to the fallacy of that process. And we look at a historical approach, which I recommend to you. And we're also going to ask ourselves hard questions which arise very much from Indian constitutional law, which is the extent to which there can be principles or law beyond the words of a constitution itself. And you're all constitutional law students, so you'll be very familiar with what happened in India in the 1970s and 1980s when judges, some very heroic judges, Justice Khanna in particular, resorted to the idea of justice and law beyond constitutions. But for today, I just want to talk about affinities, legal affinities, constitutional affinities, and we'll be looking at all these other issues in much more detail. I think that the affinity between Little Ireland with 4 million people, our population is smaller than that of Hyderabad, and India. I think the extent of the affinities between our two countries has been underestimated by scholars. We're not very, frankly, in the world stage, we're not very important, so I can understand why that might be. But I think our constitutions are sisters. And if you look at that brochure which I handed to you earlier, I think I can identify up to 20 or more than 20 close resemblances. You needn't bother looking at it now, but that happened because in 1946 Sir Benegal Rao. Do you know who Sir Benegal Rao was? He was the legal advisor to the legal committee. He's the legal advisor to the legal committee of the Constituent Assembly. He, as I said, went on a tour of Canada. He met a man called John Hearn, who was the Irish ambassador to Canada at the time. But John Hearn had in his previous life written the Irish Constitution along with Eamon de Valera. So when you go to issues like directive principles of social policy, they're the people who actually conceived of this. And it was Sir Benegal Rao who became an adherent of this, who brought the idea back to India. That's not to say, I'm not going to for a moment saying that we have to look at it and say, gosh, we owe everything to Ireland. That's not the way constitutional making works. Constitutions, even this constitution, ours, borrows from the American Constitution, the French Constitution, principle, the Weimar Constitution of Germany in 1919. So there's always a process of osmosis going on. When you're engaging in that comparison, it might be fun for you to actually Google the 1937 Irish Constitution original text. Look for original text, because it identifies, it symbolizes, I think, so many of the stark choices that the Indian framers had to make in the 1940s. The politician, this isn't just unhistorical background. It was something the politicians themselves saw way back to the early 1900s, when a man, quite a number of Indian young men, they were all men, were students in King's Inns in Dublin. Between 1913 and 1916 there was a general strike in Dublin, and then there was a rising, which involved the occupation of the GPO and the forecourts where I work. And just before that rising, there escaped back to India a man who organized a general railway strike in 1928 and who became very involved in Indian constitutional history. It was President Geary, who studied law in Ireland. You know about Patel. His brother Vijay Patel was involved and closely linked with the Irish nationalist movement. Nehru was very involved and very closely linked. He studied Irish nationalism. And there you see the culmination of that relationship, which is De Valera and Nehru visiting. This is Eamon de Valera came to visit Nehru here in India in 1948. That's, as you will know, a pivotal year in Indian constitutional history. But those links went back to the 1920s and 1930s and even earlier. Gandhi deplored the way the Irish independence movement had resorted to violence, but others like Chandra Bose took a different view. The way in which, what's really important, I think, for our constitutional studies, and this is a paradigm for every constitution we'll be looking at, and every process of interpretation we'll be looking at. And I'm only scratching the surface, I'm not going any further than that, is just to look at the way in which the values of 19th century, first of all the values of the 18th century rationalism, rights of man, and also the United States Constitution are embodied in both constitutions. Then we go to the second layer, nationalism of the 19th century, and that created and was necessary to express the idea of the nation, as you see in the Indian Constitution, embodied in the state. But a newly independent sovereign nation carried with it the reality that it had an image, a vision. And in Ireland, I speak of Ireland, and also I believe of India, if you didn't come within the category of those who were within the vision, it was not always comfortable if you were a minority outside. We look at the way in which constitutions, when you look at the Irish Constitution, look at the Indian Constitution, the way in which there are symbols and signifiers of nationality, such as the reference to the national flag, to the national language. Very, very similar. And these are all values emanating from 19th century nationalism. And then running in parallel with that is the other great historical force in the 19th century, that's socialism. And we look at the way in which the whole issue of the purpose of independence arose. You don't just get independence and just say, great, we have achieved the new millennium. The purpose of independence, both in Ireland and India, was sought to be a particular form of vision. And if you were a Dalit in the 1940s, or if you were an Irish small farmer in the 1920s, you'd ask yourself, well, what difference does this make to me? The difference could only be seen in the context of the social effect, the economic effect, if possible, of independence. So it's not only about sovereignty, but the uses of sovereignty. So that's the second force that comes. And then there's a third remarkable dimension, the extent to which Eamon de Valera, who we saw on the one hand a moment ago, and also Gandhi shared a kind of panchayat ideal of the rural idyll, that society was best predicated on living in villages and on village life. Against that, there's a tension, just as there was in Ireland, where there was a leader of de Valera's party, Sean Lemass, who strongly believed that the vision should be of industrial society. And here, Dr. Ambedkar, who deprecated the whole idea of village life. So, we've a huge number of other similarities. The risk of alienating minorities who perceive themselves excluded from the national vision, the pursuit of neutralist, non-aligned foreign policy, and it has to be said frankly, the whole concept of non-Britishness, the extent to which independence was to be asserted on the basis of what we're doing is not British. And we will go to the United States, we will go to France, when we go to other countries when we're looking for at least some of the values that we're going to embody in our Constitution. So, when we're looking at and interpreting constitutions, we'll be looking at the way in which particular forms of interpretation sometimes lead to particular forms of outcome. Not always, but for example, a literal or textual interpretation where you resort to the origins, the originalism, will often lead to a result which is unlikely to lead to constitutional innovation or creativity. And I want to talk about, very briefly, about one fundamental distinction between what happened in Ireland and what happened in India. That is, in Ireland, and we have to remind ourselves, I'm a city dweller, and I never realized the extent to which, when you're living in a rural society, land equals wealth, or if you're poor, land equals survival. Will you have enough crops to eat? Will your family have enough crops to eat? In Ireland, we had the tragedy of a famine in the 1840s where over 1 million people died. In India, you unfortunately had the tragedy of 1943. And we both shared the experience of extraordinary administrative indifference, where in Ireland in 1845, 1846, 1847, there was an insistence on a continuation of exports of wheat, and precisely the same was to be seen in India when Churchill was insisting on exportation in 1943, even at the expense of hundreds of thousands of lives. So we have a great deal in common. I could take other examples, like the Hindi word for a chariot is, I think, rat. The Irish word for a wheel is rut. Ri is a king in Ireland, in Irish, Raja. So the study of philology and history and culture shows us something about our background. And I could speak a great deal, and we might get the opportunity on another occasion, of talking about what is called the Celtic Revival, when Ireland and India and Irish culture and Indian culture and literature found each other in the early 20th century, particularly personified by connections between Tagore and W.B. Yeats, the great Irish poet, and Tagore, the great Indian poet. It was effectively a kind of early 20th century bromance, where they suddenly identified in each context common elements. And what the Irish were looking for was to be seen in the context of the English educational system which had been introduced in Ireland, which had effectively devalidated Irish culture and Irish language, and sought to impose an idea of Ireland as being a province of Britain. What was necessary then was validation and identity. And when we talk about dominion, as lawyers we're talking about the dominion of Canada. But there was another meaning of dominion, and this is something I believe we share. It's a post-colonial meaning of dominion, and it has a darker meaning, and it arises in the context of exploitative or abusive relationships between adults and children, where the victim is rendered powerless and where their identity becomes almost subsumed in the dominant figure. And that's very similar to the way in which cultures can become subsumed in the dominant culture of an imperial power or colonizer. There are similarities also in the way in which there were two strands of opinion throughout the independence movements. We already saw a picture, there's Yeats and Tagore. There is a picture of Tagore that's in Stephen's Green in Dublin. We saw Tagore earlier. He admired Michael Collins. There was a picture of them beside each other, who was the great leader who was shot in 1922, but who had led the Irish War of Independence. Both saw the future in terms of the potential for an independence movement. You know his involvement in anti-British activities during the Second World War. He admired Collins. There were very many contacts between Irish nationalists and Indian nationalists in the 1920s, 1930s. In 1932, there was a large meeting in Dublin to support the cause of Indian independence. There were continuing contacts between Nehru and De Valera. And to an extent, I believe that what happened in Ireland, you saw the picture earlier of partitioned Ireland. I believe that when you look at even Dr. Ambedkar's speech in his last speech to the Constituent Assembly, towards the end of it, he's referring to an Irish example again, John Redmond, who is the leader of the Parliamentary Party. What happened in Ireland, very briefly, was that there was the separatist Irish nationalists, a faction of them, engaged in a rising, a rebellion in 1916, which was absolutely criticised by the public. But the British shot the leaders, 16 of them, public opinion changed, as a result of which the War of Independence followed, and thereafter that culminated in a treaty made in 1921 between Ireland and Britain. But there was partition, because the minority in Northern Ireland, who were largely Protestant people, considered that home rule would be Rome rule. Partition, minorities, do these perhaps strike a little chord? So, what we're talking about is the principle then of the way in which constitutions embody not only the text but also the spirit of a nation. Of course, constitutions contain lots of other materials such as courts, finances, and in the case of India, states. But what I find fascinating, and I hope you will too, is the way in which you will see the spirit and the heart of the Constitution, and the way in which it was hoped Constitution would actually give expression to national aspirations is so very similar. So, when I speak of the issues which were facing the Constituent Assembly, I don't want to be taken as speaking only of men. There were women, Ms. Pundit, Ms. Unmarried Kaur, Ms. Pundit, who a few months before resigning, she became, if you remember, the ambassador to Moscow, and became the first woman president of the United Nations General Assembly. Ms. Kaur, who drafted the Indian Women's Charter of Rights and Duties during the 18th All India Women's Conference in Hyderabad in 1946. Ms. Mehta, and Sumita, who was a member of the Fundamental Rights Subcommittee. So this is a process, an extraordinary process, engaged in by men and women who are making India. But they weren't just shaping and making India for 1948 or 1950, they were making it for the future. For myself, I just want to say what a privilege it has been to engage in this process. I've learned so much about Indian history. It's moving. All of you who learned it in school, I'm sure you say, well, that's what happened in 1946. But for me, the way in which these people, men and women together, brought about Indian independence is an extraordinary thing. Because when you look at the diversity, the principalities, the way in which it was necessary to bring everyone on board, the achievement was absolutely astonishing. In Ireland, we had landlordism. In India, you had the princes, you had great landowners, all of whom were allies of the British because they had a stake in the game, in the status quo. In Ireland, the land question was resolved towards the end of the 19th century, or at least an effort was made to resolve it. And I merely touch on that because one of the issues that we touch on and explore is the extent to which the pressure that was on the Indian courts in the 1950s and 1960s and 1970s was about land reform and was about economic and social issues. That isn't what happened in Ireland, and we remained a very static society until the 1960s, when there were social changes which took place and which we'll explore. I want to say what a privilege it is to be here. I want to say I hope you enjoyed the course as much as I've enjoyed the exchanges with all of those who are involved in the process. And I hope that at the end of it, as I will, that we'll all go out of it saying, gosh, we did learn something from this course, that we might actually go back, me to my job, you to your studies, and then to your jobs afterwards, and say, actually we did take on board something there that will stick. And for me, I merely want to say that I feel extraordinarily honoured to be involved in this process. I want to thank you all for being kind enough to come. Thank you very much.
Thank you so much, Justice MacMenanim. Now, we have deliberately kept the introductory session a little smaller. We still have some time, with the idea that all of you might have questions. Also, in terms of what is it that you are expecting to see over the next 6 days, and if possible, we will ensure that we're covering those areas. And to make it more interesting, it was Justice MacMenam's idea that perhaps we have a small prize for the most interesting question, and we have a Constitution of the Ireland which will be signed by Justice MacMenamin for those who have the best question for the day. And we have a prize for every day, and we have a prize for the course in addition to whatever grades that you might get. We have a special prize at the end of the course for the most involved student. So this is added incentive in case you don't have enough incentive to ask questions. We are hoping that we will get some interesting questions. So we have allotted time every day for questions, and as we move on, we are looking for more involved interactions with all of you. But for today, we'll start with questions. So.
If you don't ask questions, we'll all go home. Okay. All right. Well, we'll have yes, sorry.
While referring to the affinities between the Indian and Irish history, you referred to the famine. Now, how is it that something like the famine plays out into an analysis between the constitutions? How is that significant while we are discussing the constitution? Because, to my mind,
one of the defining features, I'm talking about Ireland, was the residual effect of the famine. Not only did the Irish population diminish from 8 million in 1945